Hi, my name is Jamala McFadden. I am delighted to have been asked to present this installment on LifeForth. Today I'll be talking about severance agreements. And this topic is part of a broader topic about things to consider when you're leaving your company. The first thing is, what if a severance agreement has not been presented to you by an employer? My general advice is still ask. It doesn't hurt to ask for some kind of compensation or other things that we'll get to when you are exiting the company. And there are various reasons that the company may be inclined to give you some form of severance or separation benefits, even if the benefits are non-monetary. There might be an opportunity for you to obtain severance benefits anyway, if, for example, you have an employment agreement that requires the payout of severance benefits at the time that your separation ends. Many of us don't have employment agreements, but if you do, remember that document and go back and take a look at it to see if it says anything at all about benefits that might be provided to you in the event that your employment ends. The other thing to think about is if the company has a practice of providing severance benefits when an employee departs. So it could be that Joe and Jane and 3 other managers at your level have been given some kind of severance benefits, then you have an argument that you should be given some benefits as well. And something that comes up, it's less likely, but it does come up, if you've had a supervisor that has offered you or has promised you some kind of benefit when you leave in exchange for maybe staying on with the company for longer than you intended, or some other circumstances that might be in play, you may be able to rely on that promise as grounds for you to obtain severance benefits from the company as well. So don't give up. Just think about whether or not there are opportunities or avenues that you can explore to at least form the basis of your request for severance or separation benefits. A lot of clients come to me when they have been given a severance agreement already, and they want to know what their rights are, what the options are. Do they have any power to negotiate? What on earth should they ask for? What should they not ask for? And that's typically the context in which I get involved. If you have a severance agreement and you're considering what to do, my first bit of advice is take your time. Take your time and review the agreement. Sometimes you're presented with a severance agreement in an involuntary separation situation. And so emotions are just running wild. You don't know what to do. You've been at the job for years and years, and you're just trying to figure it all out. But stop for a moment, just take it in, and then figure out what you want to do in terms of the severance agreement. The most important thing to do is figure out what your timing is. Sometimes you will be told in a meeting that you have 7 days to sign this agreement. Other times you will not be told, but the agreement should have some information about how long you have in order to decide whether you want to accept the terms of the severance or negotiate them. Now, after you've done that and you figure out the timing, next thing you want to do is figure out if what they're offering you is reasonable, if there are other things that you want in addition to the severance, and you want to think about whether they are asking you to do something that you were not already obligated to do. For example, if part of the severance agreement asks you to agree not to compete with the company, you didn't already agree with the company that you wouldn't compete, and they try to get it in through the severance agreement, that might be an opportunity for you to even ask for more benefits in exchange for providing that benefit to the company of not competing with the company for their business. So when you think about what to ask for, you want to think about things that might not be readily apparent, things beyond money, I should say, right? So you want to ask for more money, maybe in exchange for what they're asking you to do in the severance agreement. But there's money and then there's cash equivalents. So you may want more medical benefits, for example. Just really think about what you want and need, and also think about what you want to do next. So if, for example, what you want to do next is open a business, sure, more money would be nice, but also there might be some things like office furniture or your computer or your other electronics or office space for a period of time. There could be a number of things that may help you in your next venture that the employer may be more willing to give up than straight cash. The other thing that you might want to think about, whether starting a business or not, is whether there's an opportunity for you to remain on with the company in some capacity. Maybe you can be a consultant. It could be the case that your services are valued and needed, and the company really needs your help in making a smooth transition, either to a new employee or employees, or somehow transitioning the work that you were doing. It might also be beneficial to you to have a letter of reference. That's something that you can ask for. Outplacement services, that's another thing. And when we talk about cash equivalents, I've helped executives negotiate for a larger contribution to their retirement plan, even. Your stock options, you can negotiate for when those vest. So just think outside of the four corners of the documents that you have been given, and think about what it really is that you need. Now, the next thing to consider too is what you are already entitled to receive. So if, for example, they say in the severance agreement that they will pay you out vacation, you may already be entitled to receive vacation. So that's not anything in addition. That's not additional value that should compel you to do what it is that the company is asking you to do in that severance agreement. If you owe the company money, like for example, moving expenses, if you are leaving the company before time that you will have repaid the company's investment in bringing you on there as an employee, that might be something you want to negotiate, because some employers have been known to go after employees for even things like moving expenses if they are not repaid. Now, understand what your company wants as well. And this is a good way to get some leverage too, and help you in your negotiating position. So the company will want a number of things in the severance agreement. One could be the restrictive covenants that I mentioned. The company could want you to agree not to compete. And again, that ups the value of your severance. The company also generally doesn't want you to say bad things about the company when you leave. So they want you to leave relatively happy. So they may be willing to put some money or other benefits on the table to get that done. They also want a release. So if there is a chance at all that you may have some kind of claim against the company, be it some kind of discrimination or retaliation claim, or claim involving wages or any kind of contractual issues, they want for you to go away or walk away with a clean slate, and they don't want to have to worry about you potentially filing a claim against them in the future. So you do have some leverage if you really stop and think about what it is that the company could want for you in exchange. When people decide to come to me, most often they have decided that they at least want to consult with a lawyer. But really think about, should you hire a lawyer? Now, I know it might not be in my best interest to say no, but sometimes I do advise clients that maybe you should think about not getting a lawyer involved, at least perhaps in direct negotiations with the company. So the reasons to hire a lawyer: one, it creates some distance between you and the process. So sometimes as employees, we're emotionally connected to it, especially if we've been in a place for a very long time and the departure or the separation is a surprise. Sometimes it's difficult to kind of disconnect. So a lawyer provides a neutral, if you will, to really, and it's emotionally detached, so they can really evaluate the business or the economic terms of the agreement. A good employment lawyer also will be able to understand the terms of the agreement and explain it to you. They'll be able to explain sort of our legal jargon in a way that you can understand and determine whether or not the severance that's being offered is good for you or not. They can also, a good lawyer can help you determine what your leverage points are. Do you have any leverage? Do you have any room to ask for more? Are there any potential issues that the company may be concerned about that might increase the value of your release? Also, perhaps the company will take you more seriously if you hire a lawyer. Sometimes if a lawyer is saying the exact same things that you're saying, because a lawyer is doing, and because you've made the investment in hiring a lawyer, the employer might take your claims a little more seriously. So those are some reasons to consider hiring a lawyer. The reasons why you may not want to have a lawyer engage in direct negotiations: one, there is the financial expense of it. And when you're facing a job loss, the last thing you want to do sometimes is think about paying out more money. But if you hire a good employment lawyer, it may well be worth the investment because the value of your severance could be increased. The other reason to consider for not hiring a lawyer to engage in direct negotiations is sometimes when you hire a lawyer and it puts the employer on the defensive, their backs get up against the wall. And even if they were inclined perhaps to engage with you and give you more in the way of separation benefits, because they feel attacked by a lawyer, they may shut down in a way, which is not productive to you. The other kind of real life reason is it is very likely that you want to work or have some business dealings after your company. And sometimes word may get around, despite confidentiality provisions, that you were the one who sued or threatened to sue your former employee. So long term, that might be something that you decide is not in your best interest. But even with all of that, I have very often negotiated behind the scenes, helped a client behind the scenes to ghostwrite emails or just give them general advice to arm them, empower them, if you will, with the information that they need to handle the direct negotiations with their employer. So those are some considerations. I'm happy to answer any questions that you may have about the process, about agreements, about kind of what's next for you and some things that you might want to consider asking for. This has been Jamala McFadden. You can reach me at Jamala McFadden at LifeForth, LifeForth.com. Thanks so much.